Remember, we are the media now. Hi, Linda here, and thanks for joining me. Today, I'd like to talk about the State Farm files and ongoing litigation. Some of you may know that my roof blew off in February of 2019. And as a result of the mishandling of the claim, I was exposed to toxic exposure and catastrophic damages were done to my home. This claim was accepted by State Farm. They required me to use their preferred vendors, and then they made up stories about all of that. So this is in Superior Court of the State of California for the County of San Bernardino. It is case number CIVSB 2106284. The courts have granted me leave to amend the third amended complaint. So we're on the fourth amended complaint now. The causes of action are 1, breach of contract, 2, breach of the duty of good faith and fair dealing, 3, intentional interference with contractual relations and conspiracy, 4, fraud, 5, intentional misrepresentation, 6, negligence, 7, toxic exposure, 8, RICO. RICO stands for racketeering, influenced, and corrupt organizations and conspiracy. I've also demanded a jury trial. There were initially 10 defendants with does 1 to 250. Last year, 50% of them reached settlement. That's another story for another video, but what is. Right now, it's Linda Ayers, the plaintiff, versus State Farm General Insurance Company, a corporation, Crawford Contractor Connection, a corporation, Paul Davis Restoration, Inc., a corporation, Desert Valley Restoration, Inc., doing business as Paul Davis Restoration and Remodeling of Greater Palm Springs, California, American Enviornmental Group, a McLaren's Company, a corporation, and does 1 to 250 inclusive. So let's see, I want to share my screen with you. So let's do it this way. So what I want to talk about is the court granting leave to amend. And we'll just go through if you're a public adjuster, if you're an attorney, if you're a policyholder, it may be of interest to you. My story's not uncommon at all. So don't let my story become your story. Okay. On the third amended complaint is exceedingly difficult to follow as it rambles with multiple unrelated claims of error in the facts and causes of action, including discovery requests and claims of conspiracy. The court makes the following finding related to the demurrer and motion to strike of the third amended complaint for Paul Davis Restoration. The court rules as follows: overrule the demurrers to the first and second causes of action, sustain with leave to amend the demurrers to the third, fourth, fifth, seventh, and eighth causes of action. The motion to strike is moot due to the demurrer ruling. For State Farm, the ruling is 1, the court admonished the plaintiff for filing an oversized opposition brief without leave in violation of California Rules of Court, Rule 3.1113 for ND. Number 2, as for defendant State Farm General Insurance demurrer, A, the court overrules as to the first and second causes of action. And B, the court sustains with leave to amend as to the third, fourth, fifth, and eighth causes of action. C, the court sustains without leave as to the sixth and seventh causes of action. The court grants defendant State Farm's motion to strike attorney's fees allegations. Number 4, the court deems the motion to strike RICO and punitive damages allegations moot in light of the demurrer ruling. 5, the court otherwise deny the motions to strike. AEG ruling. Number 1, the court admonished plaintiff for filing an oversized opposition brief without leave in the violation of California Rules of Court, Rule 3.11113 for ND. 2, court denies defendant American Enviornmental Group's demurrer to strike the entire TAC. 3, the court overrules defendant American Environmental Group's demurrer to the third cause of action. 4, the court sustains the demurrer to the fourth, fifth, and eighth causes of action with leave to amend. And 5, the court grants American Environmental Group's motion to strike without leave to amend. Don't know what that one means. Okay. Now, the AEG it talks about a request to strike the entire TAC as untimely filed. AEG asked the court to strike the entire TAC on grounds it was not filed within time period authorized following the sustaining of AEG's previous demurrer. Court in part sustained the demurrer to the prior SAC on April 13th, 2022, with leave to amend. The minute order did not state the time period in which the plaintiff could amend, but AEG's subsequent notice of ruling filed April 18th, 2022, provided the court granted 60 days leave to amend. The docket now shows the TAC was not filed until July 6, 2022. Although the TAC was filed beyond the deadline, it is now on file and the instant demurrer has been fully briefed on the merits. The court denies AEG's request to strike the TAC. That's a topic for another discussion on lawfare and trickery and not nice tactics by lawyers. Okay, so now let's talk about the current rulings. AEG is the only defendant that was heard in the first practically 2 years of litigation. And I understand that is just typical lawfare. It's not very nice. It certainly obstructs justice and it overburdens the co-defendants, the courts, and it's intentionally designed to overburden and cause adverse impact to the plaintiff, me. I'm elderly, I'm disabled, and I'm self-represented. So let's see what the judge ruled in December. They heard Paul Davis Restoration, State Farm, and also they heard AEG for the fourth time. Contractor Connection has done, I forget what it's called, affirmative defenses. And so they haven't been heard yet, but they are also doing a cross complaint against Paul Davis Restoration. And apparently Paul Davis Restoration and Contractor Connection have to indemnify State Farm, regardless of the guarantees that allegedly come with their work. AEG allegedly has no such indemnification agreements with State Farm, but all of these parties were assigned by the Arizona desk adjusters. Randy Brewer, Randy Brewer, Roy Painter is the adjuster team manager. Joey Camiso was also involved after the stuff hit the fan. Okay, so let's go through this quickly. If you have any questions or any feedback for me, that would be great. I have to get these amendments done, and I haven't been able to find lawyers, so I'm going to give it my best shot. But here's what the courts have ruled. Breach of contract, first cause of action, breach of implied covenant, etc., second cause of action for Paul Davis Restoration. The plaintiff alleges that PDR breached his contract regarding the duties owed to State Farm's insured by delaying in getting the roof replaced. The third amended complaint alleges the existence of a contract, PDR's breach, and resulting damages. There is no need for plaintiff to outline the contract terms verbatim or attach a copy to the complaint, since those are merely available methods of pleading the contract. But all that is required is for the plaintiff to plead, quote, the legal effect of the contract rather than its precise language. The contract's legal effect has been alleged in this case, whether a breach of an express or the implied covenant of the contract. PDR's alleged incompetence is a valid basis for the contract claim since it's purportedly agreed to act competently. The resulting mold damage and additional water intrusions are not too speculative for pleading purposes. The demurrers are overruled. For State Farm, from the first cause of action for breach of contract, the court ruled Plaintiff alleges State Farm violated the terms of the insurance policy, but does not attach the policy or quote it verbatim. Plaintiff alleges State Farm breached the policy in denying its claim and in failing to prevent additional damages. State Farm agreed to provide coverage for the loss or damage to plaintiff's property. Plaintiff paid premiums and performed or substantially performed. This is sufficient to plead the legal effect of the contract. The allegations are otherwise sufficient at the pleading stage to place State Farm on notice of the breach. The allegations are otherwise sufficient at the pleading stage to place State Farm on notice of the breach. The court overrules the demurrers to the first cause of action. And the second cause of action was included, and I've already read that to you in Paul Davis Restoration. What the court said further regarding State Farm, the second cause of action for breach of the covenant of good faith and fair dealing. Plaintiff alleges defendant unreasonably and in bad faith denied plaintiff's insurance coverage to which she was entitled under the policy by failing to perform a fair, objective, and thorough investigation, asserting invalid coverage defenses, delaying resolution of the claim, placing unduly restrictive interpretations of policy terms, failing to give plaintiff's interests equal consideration, and forcing plaintiff to institute litigation to recover under the policy. The allegations are sufficient to allege bad faith at the pleading stage. The court overrules the demurrer to the second cause of action. For Paul Davis on the third cause of action, this cause of action is uncertain as it refers to both Business and Professions Code, section 17200, unfair competition law, close paren, and intentional interference with contractual relations. These are two very different claims and cannot be pleaded in a single cause of action. Okay. The demurrers are sustained with leave to amend. For State Farm, the third cause of action for interference with contractual relations and conspiracy. The complaint alleges State Farm intentionally interfered with contractual relations between plaintiff herself and third-party vendors by failing to pay for such service, forcing plaintiff to pay herself. It is unclear how this was designed to induce a breach or disruption of plaintiff's contractual relations with those vendors. The court sustains the demurrer to the third cause of action with leave to amend. AEG, third cause of action for interference with contractual relations and conspiracy. The court has previously overruled AEG's demurrers to this cause of action twice. AEG cites no legal authority whatsoever in support of its argument as to this cause of action. AEG argues the third cause of action lacks allegations of terms certain enough to form a contract, and therefore contends there could be no interference. However, as has been repeatedly determined in relation to other previous demurrers, plaintiff adequately pleads the existence of a contract between herself and the defendant State Farm with which plaintiff interfered. This is effectively a rehash of prior demurrers which were overruled. The court again overrules the demurrer to the third cause of action. Fourth cause of action. Paul Davis Restoration. Fraud, intentional misrepresentation is the fifth cause of action. Although the third amended complaint refers frequently to, quote, defendants, there are several examples of specific statements attributed to PDR's representative. However, the ability of the individual to speak for and bind the corporation is not alleged, nor does plaintiff clearly allege reliance on the statements. The demurrers are sustained with leave to amend. That's for 4 and 5. State Farm, fourth cause of action for fraud and fifth cause of action for intentional representation and deceit. Plaintiff fails to allege specific representations that they were known to be false, intent to defraud, and reliance. State Farm argues any alleged misrepresentations were by service vendors regarding the work they performed, not by State Farm. Some of the misrepresentations are alleged to have been committed by, quote, defendants, without specifying which defendant made the misrepresentation. Others allege State Farm made other misrepresentations, but do not state who at State Farm made those statements. Plaintiff alleges State Farm adjuster manager Roy Painter advised the California Department of Insurance that $14,000 was paid to the plaintiff when coverage was for $136,650. Plaintiff further alleges State Farm adjuster Randy Brewer told plaintiff she could not contact Phil at Elite Roofing, but this is not alleged to be a misrepresentation, and it is not alleged when this occurred. There are no specific allegations of misrepresentation made by any named individual at State Farm to plaintiff. The court sustains the demurrer to the fourth and fifth cause of action with leave to amend. For AEG, the fourth cause of action for fraud and the fifth cause of action for intentional misrepresentation and deceit. To sustain a fraud-based cause of action, a plaintiff must allege 1, misrepresentation, false representation, concealment, or non-disclosure. 2, knowledge of the falsity. 3, intent to deceive. 4, justifiable reliance. And 5, resulting damage. The particularity requirement for a fraud-based claim necessitates pleading facts that show how, when, where, to whom, and by what means the representations were tendered. The plaintiff must state particular allegations with regards to corporate defendants, such as the names of the persons who made the misrepresentations, their authority to speak for the corporation, to whom they spoke, what they said or wrote, and when it was said or written. Plaintiff repeatedly makes general allegations of various misrepresentations by unspecified, quote, defendants, although there are now some specific allegations. Plaintiff alleges AEG provided false reports in March and August 2019. Plaintiff alleges it is unknown whether AEG conspired with State Farm on the false reports or was, quote, was victimized, unquote, by State Farm. AEG falsely represented the air samples taken from the home, quote, would be done professionally, unquote. But the false testing results were, quote, well below common sense and industry standards, unquote. Plaintiff appears to allege by her reliance on the March 2019 report that the property was safe. AEG intentionally endangered her. The March 2019 report is attached to the TAC, although it does not appear to have been provided an exhibit designation. AEG's demurrers to these fraud-based claims have already been sustained twice. Each time, plaintiff filed to make her allegations with sufficient particularity. As was the case previously, it is not alleged who made the representations by name or title, how the report was communicated, i.e. via mail or email, where the fraud occurred, etc. The ability of any individual to speak for and bind the corporation is not alleged. In her opposition, plaintiff cites the names of numerous persons who were purportedly involved, although they were not named in the TAC. The court sustains the demurrer to the fourth and fifth causes of action with one last opportunity to amend, as plaintiff has now provided more information regarding the specific misrepresentations allegedly made in the March 2019 report. Footnote 1, presumably the persons who created the false March 2019 report, which is attached, were its signatories. Nevertheless, such is not pled in the body of the TAC, and plaintiff similarly does not allege who specifically represented the report would be performed competently. Okay, and so number 5, the fifth cause of action has already been addressed. There, reason number 6, State Farm, the sixth cause of action for negligence. Plaintiff's claims against State Farm sound in contract and perhaps fraud, not in negligence. Any negligence claims are properly made only against the contractors. The court sustains the demurrer to the sixth cause of action without leave to amend. Number 7. State Farm toxic exposure, seventh cause of action. This claim sounds in negligence and therefore does not apply to the defendant, State Farm. The court sustains the demurrer to the seventh cause of action without leave to amend. Toxic exposure, seventh cause of action, Paul Davis restoration. The third amended complaint alleges the defendants failed to disclose the risks and to mitigate the risks to plaintiff of mold contamination. The demur cites no law, but argued that this is a negligence claim. The claim in this case sounds in negligence since it is essentially alleged, but the defendant's conduct plaintiff would not have been exposed to toxins. Mere exposure itself is not necessarily enough, but there must be actual harm that the results in the same concept is true under negligence law. There is no clear allegation indicating that PDR's conduct actually caused plaintiff to suffer a specific medical harm. The demur is sustained with leave to amend. It was already some of these that AEG is not being mentioned in were already overruled because AEG was heard by the only defendant that was heard by the court in the first almost 2 years. And now we get to RICO. The eighth cause of action for RICO violations, State Farm, a pattern of racketeering requires 2 acts of racketeering. All of the alleged offenses in this case relate to one commercial transaction and involve a single victim and single injury. This court finds that plaintiff has not sufficiently alleged a pattern of racketeering activity. The court sustains State Farm's demur to the RICO cause of action with leave to amend. Paul Davis restoration, eighth cause of action. The third amended complaint contains only conclusory allegations that defendants conspired and colluded with each other by essentially committing fraud and drawing out the insurance claim process and expanding its scope. It does not clearly outline which enumerated acts within RICO statutes were committed, at least with legal citation. To the extent that RICO claim is based on PDR's alleged fraud, that claim is not sufficiently stated. It is not enough for plaintiff to generally allege fraud, since the fraud or other conduct underlying the RICO claim must be one of the enumerated acts under the RICO statute. The demur is sustained with leave to amend. AEG in racketeering. The eighth cause of action for RICO violations. RICO requires the conduct of an enterprise engaging in or affecting commerce through a pattern of racketeering activity that causes injury. To prove a RICO claim, a plaintiff needs to establish 1, conduct, 2, of an enterprise, 3, through a pattern, 4, of racketeering activity, 5, causing injury to the plaintiff's business or property. Racketeering activity is defined in the United States Code, Title 18, Section 1961, paren 1, as any number of specifically enumerated acts. A pattern of racketeering requires 2 acts of racketeering. The court has previously sustained AEG's demur to this cause of action twice. The TAC contains only conclusory allegations that, quote, defendants conspired and colluded with each other by essentially committing fraud and drawing out the insurance claim process and expanding its scope. The TAC does not clearly outline which enumerated acts within the RICO statutes were committed. To the extent that the RICO claim is based on AEG's alleged fraud, that claim is not sufficiently stated. While fraud is identified within 18 U.S.C. Section 1961, only specific types of fraud appear to serve as the basis for a RICO claim, such as, quote, wire fraud. Fraud relates to, quote, access devices, etc. It is not enough for plaintiff to generally allege fraud, since the fraud or other conduct underlying the RICO claim must be one of the enumerated acts under the RICO statute. The court sustains the demur of the eighth cause of action with leave to amend. So that's the basics of the amendments that I have to, the causes of actions that I have to amend. Also, because of the lawfare that was involved and the abusive discovery that came with each time AEG was heard on the demurs and strikes, the complaint grew to over 170 pages. So I have to pare that down too. I think the initial complaint in February of 2021 was like 50 pages, then there were 10 defendants. So there's a lot of work to be done. It's unfortunate that I can't find legal representation or even legal assistance to help clean this up. I am a boomer. I do have cognitive disabilities. I hurt my brain at work in 2012. I have not worked since that time. Defense counsel, lead counsel that has been involved in litigation support, apparently has a background in harassment and bullying. And it's been brutal. This is not just about what State Farm and its unlawfully assigned preferred vendors did to me in my home. This is happening to policyholders across America. So I just wanted to let you know what's going on and how if you have State Farm insurance, you better hope you know somebody in the legal world, or you better learn PDQ about how to represent yourself. Because as I mentioned, I think in previous videos, I've been told by other attorneys that I am on a blacklist. And that's just wrong. It's just absolutely wrong. I did speak with one attorney when I mentioned that, and the response was, I know about that, and I probably know a great deal more than you have any idea of. So I think perhaps the misconduct of some of the attorneys in this case might also make the RICO case a little bit, the RICO cause of action have a little more teeth in it. Anyway, so that's my story, and I'm sticking to it. I hope you will join my YouTube channel. I'm getting some professional help to bring that together, and one of the goals is to, well, just to tidy it up, and also to get the number of followers over 1,000. Apparently you don't really exist in the YouTube world unless you've got at least 1,000 followers. So if you would join and follow, that would be awesome. And my blog, and we'll just kind of go from there. And if you have any questions about any of this, let me know. If you have any suggestions, or if you know a good paralegal and attorney team that might be able to help me edit this, I'm giving it my best shot now. And I also have some very abusive discovery to attend to. And I spoke to another attorney recently, and her advice was just do it. Just do it, Linda. But it's like the overwhelm, the weaponization of discovery is, in my opinion, not very professional, not very American. And some of the things that I've had to deal with have been like hissing demons. So anyway, that's my story, and I'm sticking to it. And watch for a book. It's coming soon. Thanks. Take care. Remember, we're the media now, and do everything you can to transcend censorship and expose corruption. Let's see what State Farm, if they show up at Davos, and what kind of bug-eating stuff they come up with.